friends, this is attorney Marina Shepelsky, and today's video is to give you an update late 2021, early 2022 about VAWA. VAWA is Violence Against Women Act, which is a special law partially used in immigration for men and women to legalize when they're in a struggling marriage or other relationships that have to do with U.S. citizens or lawful permanent residents. I will explain more in a minute. I have been working with clients from all the 50 states, especially in the last year and a half, almost 2 years, since the COVID pandemic, and the relationships and marriages are very strained for many people right now. Because of COVID, it added a lot of pressures, a lot of psychological and mental burdens to people, and their marriage is suffering and they're abusing each other in many cases, sadly. So I wanted to do this video to update everybody about VAWA, how it works, who can file, how long is the wait. I have a lot of notes here, so I'll get right into it. But before I do, I'm going to ask you to become a subscriber of our channel, where I create videos just like this with a lot of live hacks, explanations, immigration news every Friday when I do lives for immigrants to get better understanding of U.S. immigration law that I have learned through practicing it since 2002. All right, so here is VAWA update, late 2021. I'm doing this on December 1, recording this. And this is going to go into early 2022. Okay, first of all, what is VAWA and who qualifies for VAWA protection? VAWA stands short, it's an acronym for Violence Against Women Act. It's a big law that also is applied in immigration, amongst other things. Back in the day, 28 years ago, at that time, he was a senator. Senator Joe Biden was one of the 2 senators who pushed this law through to help women who were victims of domestic violence and were suffering, and this was applied to immigration. But VAWA works for both women and men. So even if you're a man in a bad marriage, and we have a lot of men clients, about half of our clients are men, because of the equality that we are finally reaching in every area of our lives in the United States. Now men are suffering just like women, and women are continuing to suffer in abusive marriages. And when you throw immigration status in the mix, because it's not equal with the 2 spouses, often it creates ways for one person to abuse the other, to take advantage of the other. So we are seeing a lot of VAWA petitions, and we're filing them. And I highly recommend that you hire a lawyer to help you with a VAWA petition. It's become very strict because I guess so many people are filing now that you need to have detailed everything. And I'm here to explain how to do this, but it's one of those things where I beg you not to try this at home by yourself. Get an attorney. We are happy to help you if you have a situation that qualifies you for VAWA, okay? So I explained what VAWA is. Let me explain who qualifies now for VAWA protection. And it's a protection because when you file for VAWA, it's a self-petition, which means you file the I-360 petition as you're filing for yourself. You are the beneficiary and you're the petitioner. You are in both roles here, unlike the family petitions, where let's say it's a mother, she's a petitioner filing for a green card for a child. Here you are filing for yourself. That's why it's called an I-360 VAWA self-petition. So it's a self-petition by a person who is still undocumented, an immigrant who is in a real marriage, married for love, to create a family together. And it's called bona fide marriage. It's a Latin word, expression that means it's a real marriage. It's valid. You didn't do this for papers. You entered this marriage for love. You had the intention of living with the person that you love in a contractual relationship, which is what marriage is. It's a contract, but they subjected you to abuse. So the spouse that you're living with has to be either a green card holder, lawful permanent resident at the time you married them, or a U.S. citizen. Either one works, okay? So even if your spouse never made it to US citizenship, never became naturalized, okay, you still qualify if you were living in a real marriage with them and they abused you in this marriage. So we move on to the third element, which is abuse. So you have to be an immigrant in a real marriage to a green card holder or US citizen, and they had to have abused you, subjected you to extreme cruelty. They were very cruel to you. And how we determine this is if you felt bad in this marriage. If you subjectively, meaning only you felt this way, you felt they were abusing you. Maybe to somebody else, getting slapped in the face, like for example, men in Latin American culture getting slapped in the face doesn't seem like, for a lot of men, they consider that abuse. But to an American person, even if you're a man and you get slapped in the face, that's considered that you were abused, okay? So it's subjective how you felt in this relationship. If you felt you were abused, then you qualify for VAWA. And finally, you have to show good moral character. So you don't have major criminal history. You are not the kind of person who has, maybe like, stealing or anything like that in the past. You don't have 55 arrests for prostitution or 3 arrests for driving while intoxicated. But sometimes if you have some minor things or you were arrested once or twice, it's still okay. But you have to disclose it honestly. You have to be honest with immigration and explain what happened and explain maybe it's related to the abuser or so on, okay? So this is the kind of information we include when we say the person has good moral character. So those are like the 4 main elements of filing for VAWA. You are an undocumented person who still doesn't have a green card, in a real marriage, married to a green card holder or US citizen, and they subjected you to abuse, but you are a person of good moral character. You deserve this legalization, okay? Other than being in a marriage, there are other categories of people who qualify for VAWA. Okay, number 1, if you are a child of a parent who is married to an abusive step-parent of yours, the step-parent is a citizen and abuses your mom or your dad, you can qualify for VAWA. If you are a parent of a grown-up adult US citizen and they abuse you, you can qualify for VAWA. If you are an adult parent and your kid is being abused by your US citizen spouse, so maybe they don't hit you, they don't call you names, but the US citizen spouse hates your children, hits them, calls them names, you as the parent of an abused kid can qualify yourself for VAWA, and your child definitely qualifies for VAWA. So in that situation, you both can file, or the child can be your derivative, okay? So those are the people who qualify for VAWA. Let me tell you about all these different questions that I get asked that are related to VAWA, and there's a lot of them. But first, let me explain what is abuse or extreme cruelty as a legal term. What qualifies you for VAWA? Now, so I already mentioned that it has to be something you feel subjectively. In other words, you feel bad and you can talk about it, and you write this long story for them explaining all the details of how you met your spouse, or how your mom met her spouse or your dad. You explain about the dating, who proposed, who moved in with whom, when and where you guys got married, who was at the wedding, what kind of a married life did you have, what are the rituals you had, the everyday things that you did as a married couple, if you visited family, if you visited friends, if you traveled together, and then about the abuse, right? So what kind of abuse makes you qualified for VAWA? I'm going to start with mental abuse. I'm going to say financial control and abuse that you had to experience. And financial control and abuse could be your spouse controlled your bank account and they wouldn't let you use your own bank account, or maybe they added you to their bank account, or forced you to add them to yours and took all the money, ran up debts in your name and in their name. got you to be evicted, made you have to report every little cent that you spent, okay? That's all financial control and abuse. This qualifies you for VAWA. Verbal assault, verbally calling you bad names, calling you curse words, constantly telling you you're nothing, you're a dirty immigrant. If you say a word, I'll get you deported. Threats, humiliation, humiliating you with anything, forcing you to have sex when you don't feel like having sex, forcing you into sexual situations that make you feel uncomfortable. And it's different for everyone, but it could be something that you normally would never agree to. But they say, if you don't have this kind of a sexual contact with me, I'm gonna get you deported. Giving you sexually transmitted diseases, making you feel like you're terrible in bed and you're a sexual log, you're some sort of a piece of wood in bed, constantly, putting it in your mind that you're bad, you're not enough, there's something wrong with you, you're illegal, you're stupid, you don't make enough money, your family is bad, your kids are bad. All of these things are abuse, and they're abuse for VAWA, okay? Hitting, pushing, slapping you, putting their hands on you in any situation, choking you, that's abuse, obviously. Blackmailing you with your immigration status or your children's immigration status is also abuse for VAWA, okay? How do you prove you're a person of good moral character for VAWA? You give them police clearances, you send with your petition police clearances from every place you lived at for more than 6 months. But if you are from your country less than 3 years before, you have to also include a police clearance from your home country. And we usually get it through the embassy or something like that. This is where having a lawyer really helps you. You get letters from witnesses that go into the marriage, the abuse, and the good moral character of you. Maybe you helped a neighbor, maybe you volunteer, you help on Thanksgiving, with the homeless or in some organization that helps the poor. Maybe you do other support in the community. Maybe you attend church or mosque or a synagogue, and you can get a letter from them, from the church, saying you're a good person, you are part of the community, you are a morally, high ground type person, okay? What happens if good things happen to you and you got a lawyer and you win your VAWA petition? First of all, this will give you a right to get a work permit and a green card for many people. And your abuser will not have to sign one paper, they will not have to participate, and they will never find out about you filing for VAWA, okay? Also, you will qualify for many public benefits, like Medicaid, like subsidized apartment maybe, like a cheap apartment from the state. Maybe you'll get food stamps. There's a lot of public benefits that you'll be able to get if you're an approved victim of domestic violence or extreme battery, as they call it. And in some cases, if your spouse made IRS debt, tax debt, created tax debt that you didn't even know about maybe, and you just found out about, you can get the innocent spouse relief if you prove to USCIS, which is a federal agency as well, that you were a victim of domestic violence. A common question I get asked is, how long do I have to wait for VAWA approval? So from filing, it usually takes between 6 months and up to 3 years in my experience to get VAWA approved. Sometimes it's like 20 to 22 months, but sometimes it does go up to 3 years. It depends where you live, honestly, and it depends on things that are out of our control, and especially now when COVID is delaying everything. Filing for a green card with VAWA. People ask me this all the time. When can I file for a green card? Should I wait for the VAWA to be approved and then file? You can do that, but for most of our clients, we file for VAWA and the green card, the I-485 adjustment of status application concurrently, meaning in the same package they go, okay? And if you have situations with like arrests, or something else going on, sometimes we have to include waivers with a green card, but it's possible to do. For some people who have old deportation orders of removal or like old immigration judge orders You can't file directly for a VAWA green card. Sometimes you can, sometimes you cannot. We usually first do a motion to reopen and only then file for a green card. So everything is very, very personal, and there's a lot of details that you need to know when you file for VAWA. This is where having a lawyer comes in handy, especially somebody like us who does this all the time and has been doing it for like the past 20 years, okay? If you have an old immigration court order of removal, filing a motion to reopen is tricky because you have to find out if you had an old appeal, and maybe the case is now with the Board of Immigration Appeals. This was the last agency that had contact with your case. So even there, you have to be very careful and figure out where the motion to reopen goes. But it is possible to get VAWA approved if you have an old immigration judge deportation. And in this case, the minimal you're going to get is deferred action. You will not be deported, even with an old deportation. The maximum is to file that motion to reopen once your VAWA is approved. If the court reopens your case, or BIA reopens the case, then you file for a green card, you close out your court case, and you get a green card, okay? Another question I often get is, can you leave the United States and travel using an advance parole while waiting for VAWA? So the VAWA itself doesn't give you the right to advance parole, but when we file for the green card together in the same package, we usually will include an application for advance parole in the package. The fees already included in the green card application, so you don't have to pay anything extra. And if you don't have any problems like old orders of deportation, you'll be good to travel even while you're waiting for VAWA. And the advance parole is currently taking between like 4 months to 10 months in our experience to be issued. What about work authorization? Can you work legally when you filed for VAWA? So there's different situations at what point people file for VAWA. If your abuser spouse had already filed a family petition, the I-130 petition for you for a green card, we usually, when we file for VAWA, we switch the case for your green card from the I-130 family petition to VAWA. And in that case, nothing gets interrupted. The time and the process of filing for advance parole and the work authorization is based on pending green card application, not the VAWA itself. So you will get your work authorization based on that. Same thing goes for when we just file a new green card application for you. Then we file for the work permit and the advance parole based on that new green card application. However, if you have, like I mentioned, the people who have old orders of removal, they really shouldn't file for advance parole or green card. In that case, you wait for the VAWA to be approved, and then you get a work permit. They send you the work permit with a category of having VAWA approved. So in this case, it's going to take you much longer to get the work permit, but you will get it, and you will get deferred action, which is, you know, if you win VAWA, you're not deportable by the government because they give you that benefit of having VAWA approved. If the person filing for VAWA has a prior marriage and USCIS found that they have marriage fraud in their first marriage or the prior marriage, can you win VAWA then? The answer is it depends. So if you can prove that the prior marriage fraud finding was a mistake by USCIS, they reached the wrong conclusion, okay? In that case, you can file the VAWA for this marriage, the new marriage where you're being abused, and win. So again, important to have a lawyer in these situations. Not everybody that has a marriage fraud finding completely screwed for immigration purposes. There are some situations where you can overcome it, okay? If you're still living with your abuser, you absolutely can file for VAWA. They will not find out about it. USCIS is not going to tell them about it. They don't need to sign anything for VAWA. Okay, so you're eligible for VAWA and you'll get your green card. We usually have the mail go to our office and have the client have a safe email where we send them copies of everything. And of course, the green card, the plastic cards, and the work permits come to us as well. Word of caution here. Of course, we won't tell your spouse. USCIS will never tell your spouse, but you can open your mouth and tell family and friends and somebody in the community that that information might somehow accidentally get back to your spouse. So word of the wise, and from our experience, I'm going to tell you, try to not tell anybody as much as you can about filing for VAWA. Of course, you're going to have to tell the people who will be writing witness letters for your case, but caution them, make them promise to you not to tell anyone else, and especially your spouse, because they might get mad and hurt you, okay? So only tell people on a need-to-know basis. Only the witnesses should know about your VAWA case. No one else should know about it. And if you don't open your mouth, nobody will find out. Okay, we talked about still living with your abusive spouse. What about if you are no longer living with the abusive spouse? You divorced them or they died. What happens? If you were divorced and the divorce was related to this kind of abuse, you can file for VAWA up to 2 years from the date of the divorce. If you're just separated, you definitely can file for VAWA, and it doesn't matter really how long you've been separated. But if there's an official divorce on the books, it's up to 2 years that you can still file for VAWA. Same thing goes if your spouse, the abuser, dies. And we've had clients whose spouses died. The abuser died from drug use, several cases, from alcohol abuse, from liver damage due to the alcoholism, and so on. If they die, again, up to 2 years from the date of their death, you can still file VAWA and prove it, okay? And the final question is, what if my abuser got deported or somehow lost their green card status? They're no longer a lawful permanent resident. Can I still file for VAWA? And the answer is absolutely yes. If when you were married at that time and that day, they had their lawful permanent resident status or they had their U.S. citizenship, you can file for VAWA. Stay tuned for more information just like this on our channel. And I will make more videos about various immigration topics, from asylum to VAWA to family petitions to getting that 10-year green card in various situations. I'll record more videos and we'll post them weekly, okay? And tune in on Friday to our live show about the latest immigration news. I hope you have a great week. Bye-bye.